Hello, my name is Carlos Aviles. I'm with the City of Lacey. This video provides a brief overview of the quasi-judicial process and the appearance of fairness doctrine. For more information on these topics, please take a look at the materials on this page or contact the Community Development Department. Let's get started. Washington state law requires local governments to regulate land use and development proposals with constitutional safeguards, much like a court. Quasi-judicial matters are generally specific to a particular site. These types of decisions are different than legislative actions, such as adopting new zoning codes, which tend to affect a much wider area. The city created the hearings examiner role in 1979 to ensure that fair and impartial decisions are made on permits that are quasi-judicial in manner. The hearing examiner ensures that all parties receive proper due process. In Lacey, land use applications reviewed by the hearings examiner include preliminary subdivisions, planned residential developments, urban center master plans, planned community master plans, updated reviews, conditional use permits, wetland development permits, shoreline permits, appeals, and variances. In Washington state, proper due process includes the following: appearance of fairness by the decision maker, proper notice of the hearing, a proper hearing process, a complete record, and a decision or recommendation based on the record that meets legal requirements. The appearance of fairness doctrine is a rule of law requiring decision makers to conduct hearings in a way that is fair and unbiased in both appearance and fact. Washington courts developed the doctrine to ensure that due process protections, like those found in a courtroom, extend to land use decisions when a public hearing is held. Due process means that formal proceedings are carried out regularly, fairly, and in accordance with established rules and laws. The purpose of the appearance of fairness doctrine is to make sure that all parties involved in a quasi-judicial process receive equal treatment. Quasi-judicial public hearings meet two requirements. They must be procedurally fair, and they must appear to be conducted by impartial decision makers. This is a state law found in RCW 42.36. In the City of Lacey, quasi-judicial hearings are those in which the city hearings examiner or city council's role is like that of a judge in a courtroom. Like in a courtroom, all evidence and testimony in a quasi-judicial hearing must be available to all parties. For example, all technical reports submitted by a developer in support of their application are available before the hearing. This allows project opponents to have a chance to critique the report or even hire their own expert to prepare a counter response. Because quasi-judicial decisions must be based on testimony and evidence provided in the open and on the record, ex parte contact with the decision maker is not allowed. Ex parte means in the interest of one side only. Clearly, it would not be a fair and impartial process if the developer of a project were allowed to provide information to the hearings examiner or city council without public knowledge. The same applies for opponents of a project. The appearance of fairness requirements apply to all local decision-making bodies. This includes members of the Lacey City Council, hearings examiner, and any advisory boards, for example, the Planning Commission, only if they are acting on a quasi-judicial matter. In Lacey, our advisory boards only deal with legislative matters. For quasi-judicial matters, the hearings examiner creates the record and makes a recommendation to the City Council based on that record, like a court of appeals. They can only overturn the examiner if they find the recommendation is not supported by evidence or is contrary to law. The City Council, in its quasi-judicial role, reviews the record and the hearing examiner's recommendation and may approve, modify, or reverse the recommendation of the hearing examiner. If the council modifies or reverses the recommendation, the council must adopt findings of fact and conclusions of law which support the decision. Adopted findings of fact and conclusions of law must be based on the record created by the hearing examiner and must be articulated by the council. The City of Lacey staff take our responsibility to carry out state law seriously. In this case, to be fair and even-handed when reviewing land use projects, our staff works hard to ensure the permitting process is open and transparent. For more information on the process, you can visit the links and materials on this page.